Breaking news just in the past few minutes. Donald Trump has asked the Supreme Court to overturn a ruling in Colorado and ensure that he can appear on the ballot there and across the country. It was expected that Trump would take this case to the Supreme Court, but it sets the stage for a huge legal battle that could shape the 2024 election. Under the Colorado decision, the ex-president's name will remain on the primary ballot there until the Supreme Court decides to take action. The justices are expected to take up the case. As the Washington Post notes, quote, the Colorado case is just one of several novel and significant questions before the U.S. Supreme Court that have the potential to dramatically impact next year's presidential election. They add, without a ruling from the nation's high court, some states could allow Trump on the ballot, while others bar him from it. Joining us now, our very own Jordan Rubin, former Manhattan prosecutor and writer of the Deadline legal blog, plus voting rights attorney and founder of the site Democracy Docket. Mark Elias is with us. Our panel is as well. Mark, you've had a chance to look at the Trump filing. What stood out to you?
Yeah. So first of all, just on the Washington Post quote you put up, I think it's really important that we not buy into the idea that this is novel. I mean, if by novel they mean it doesn't come up that often that a president of the United States incites a violent mob to insurrection, yeah, in that sense, it's novel. But Section 3 of the 14th Amendment is in the U.S. Constitution, and it's every bit as valid as every other part of the Constitution. I have had a chance to read the brief, and what is striking about it, Alicia, is how weak it is on the question of whether he, in fact, did engage in insurrection. You know, the brief buries that question, that very central question of whether or not he is an insurrectionist, to page 27 of a 35-page file. You know, it leads with a whole bunch of arguments about whether the courts are the right forum to resolve these questions, whether Congress should have to resolve these questions, whether it is too early to resolve these questions, whether we should wait until after the general election to resolve these questions. A lot of procedural off-ramps he is trying to offer the court. And then he takes on the question of whether Section 3 is applicable to the president. You know, did he take the right oath? Is he an officer? And by the time you get to the question of whether he is an insurrectionist, it's very deep in the brief. It's only 2 pages. And much of that is spent on trying to say, well, but he didn't do the thing that people did in the Civil War. So it's not clear that his legal team feels like he's going to get the warmest reception, even by this conservative court, on the merits of whether he's an insurrectionist, but rather they're trying to provide other off-ramps, which I think in one sense is a smart strategy given the facts. I do think, though, at another, it does portray weakness. It is not, for a guy who portrays strength, this is a brief of someone who is clearly on his heels, who is portraying weakness in the legal posture he is in vis-a-vis the question of whether or not he engaged in insurrection.
So, Jordan, I want your broad read of this overall. I also want you to weigh in on this question that Mark Elias has put before us, what seems like a strategic consideration to really front load with procedural off-ramps, seeming to leave Trump's team that is actually a stronger argument than this question of whether or not he is, in fact, an insurrectionist.
Right. So I think it makes complete sense that he doesn't focus as much on whether he's an insurrectionist, in addition to the fact that he doesn't have a strong argument for why he isn't. I think all those procedural arguments and whether Section 3 even applies to the president are really going to be where the money's at in his favor at the Supreme Court, at least as compared to that factual question of whether he's an insurrectionist, because the Supreme Court isn't going to want to delve down into the muck of a question like that. They're going to want to be looking at these broader legal questions like, does Section 3 apply to Trump? And so I think it makes a lot of sense from a strategic standpoint. If you're Trump, whether it projects strength or not from a public aspect is up for debate, I think, as Mark rightly notes. But it makes perfect sense from a legal perspective that he's focusing more on those broader legal questions. So I think that's what we would expect to see, and that's what we're going to see the Supreme Court grapple with if it does take up the case.
Okay, let's talk about that if, Mark. The court, it isn't obligated to pick this up. Your sense is that they probably will, no?
Yeah, I think they're going to take this case. I think they should take this case. I agree. Rarely do I agree with Donald Trump and his lawyers, but this is a case of profound national importance. Now, mind you, there is some tension between them saying you need to take this case up and it's a profound national importance. Oh, and by the way, the court really shouldn't be deciding this case at all.
Right.
I understand that you can make that argument, but you know, I don't want people to think that when I say that he is not portraying strength, that is purely in the political arena. You know, I've argued and won 4 cases before the U.S. Supreme Court, and you know, part of what you're trying to do in these arguments is, of course, you want to offer every opportunity for the court to rule in your favor. So I completely understand why you would offer the procedural off ramps, but I do think that as you're counting votes, as he is trying to count to 5, which is, you know, what you need in the U.S. Supreme Court to reverse a lower court. I'm surprised that he would not come in with a stronger posture on the insurrection question to stiffen the resolve of maybe some of those swing, more moderate, not that there are moderates on the Supreme Court, but some of the more persuadable justices. You know, I don't think there's any question that Justice Alito will, for example, Justice Thomas will probably be with him no matter what. But, you know, if I were his legal team, I would want to give Justices Kavanaugh and Comey Barrett at least a stronger sense that you feel that you are indignant, that you are being dragged, you are being held into court on this. So I think that it's a good point that you want to give those off ramps, but I'm not sure that this was the strongest brief that his team could have filed.
Here's the thing, Jordan. We're talking about Colorado, but there are unresolved challenges to Trump's candidacy in 17 states. I believe that is the most recent number. Could the Supreme Court issue a ruling that then impacts all of those cases?
Yeah,
they have to.
Yeah. Go ahead.
Sorry, Jordan, go ahead.
Oh, no, I don't want to interrupt Mark, but I think, yes, I think if they're going to take a case that's just going to affect something like Colorado, for example, there's no point to them getting involved because then there's not going to be a national standard. They're just going to be other states knocking at their door again, or Trump knocking at their door again if he gets knocked off another ballot. So really, the U.S. Supreme Court needs to do its job and issue a nationwide resolution one way or the other, so we're not dealing with this every day, especially ahead of the general election. Now we're still in the primary. There's maybe ways that the court could wriggle out of it if it really didn't want to get involved yet. But at some point, especially before the general election, we're going to need a nationwide answer to this question from the Supreme Court.